Hello, guys. Welcome back to our audio classes on the Nigerian Law School courses. Now, like we always say, this is a lecture that you can listen to even whilst you're sleeping, whilst you're relaxing. The law school is a very tense environment, and the law school period is a very tense period. So sometimes you may not want to be in class reading, in the library reading. You just want to sit down, cooling off your head and listening to lectures. So today we're going to be talking about a course in corporate law practice. And this course is very important because it has some tricky intricacies to it, and we're going to break everything down in details. So we're going to be talking about protection of minorities under the Companies and Allied Matters Act. Now, as a general rule, where irregularities have been done or committed in the course of the management of the affairs of a company, or a wrong has been done to the company, it is only the company that can ratify the irregular conduct or sue to remedy the wrong. Now, you see, in the case of Foss and Harbottle, you're going to see it displayed on the screen. Foss and Harbottle, that's where the principle was clearly stated. If something wrong has been done to a company, it is the company itself that has the power to sue on behalf of the company. But you see, that general rule may be used by some scrupulous elements against the interest of some minority shareholders in the company. So that's why there are exceptions, and that exception is basically what we are talking about today. Now, the minority may be protected by actions of members done against the company. So you have majority shareholders, you have minority shareholders, and you have directors who direct the minds of the company on a daily basis. An action can be done that is against the interests of minority shareholders, and you don't just expect them to fold their hands and to say, you know what, until the company takes a decision to protect us, we can't do anything. In the first place, the company has taken a decision against them. Why will the company still take a decision? Yes, that's it, Foss and Harbottle. Why will the company still take a decision to protect them, where it was the company in the first place, or the directing minds, the majority, that first took the decision against those minority? So the law provides for a situation where the minority shareholders will have an opportunity to ventilate their grievances. And so that's what we're going to be talking about. So what are the options available for a minority shareholder? What are the protections available for a minority shareholder? So we'll just run through them. Number one, we have the members' direct action. So this is an action for injunction and declaration, right? And this is an exception to the rule in Foss and Harbottle. So a member may, by injunction or a declaration, restrain the company from the following. One, it can restrain the company from entering into any transaction which is illegal or ultra-virus. You see that in the case of PAC and Daily News. So you can bring a member's direct action to restrain the company of an injunction against the company on one, where the company is entering into an illegal or ultra-virus transaction. Ultra-virus means over and above its powers. Two, where the company is purporting or intending to do by ordinary resolution any act which its constitution or act requires to be done by special resolution. You see that in the case of Edwards and Halliwell. So in simple terms, the company is trying to cut corners, and as a minority, that won't favor you. You don't like that. So you can go to court to challenge that act of the company. Then also, where the company is committing fraud, where the company is committing fraud and where the directors fail to take appropriate actions to redress the wrong done. So where fraud is being committed by the company or against the minority shareholders, and of course those who are directing the minds of the company, they are not doing anything against it or doing anything about it. The minorities can say, you know what, this is wrong, let's go to court and stop them. Then you seek an injunction. So any act or omission affecting the applicant's individual's rights as a member. So for example, the majority of the company is trying to take steps that will prevent the minority from voting at a meeting. You can go to court and file a member's direct action for injunction or declaration. Then finally on that, where the directors are likely to have profited or benefited from their negligence or from their breach of duty. If I benefit from my wrong as a director of a company, I won't instigate the company to sue me. So I will just turn my eyes the other way as if nothing happened. But as a minority, that will affect me. So I can go to court to seek an injunction or a declaration. Now, you must note that where a member institutes a personal action to enforce a right due to him, or institutes a representative action on behalf of himself and other affected members to enforce any rights due to them, he will not be entitled to any damages, but only to a declaration or injunction to restrain the company and directors from doing the particular act. So, under the members' direct action, you are not entitled to damages. You are getting an injunction. All right. And injunctions are not gotten for completed acts. All right. So, injunctions are gotten to prevent or to stop. Then you're also getting a relief on declaration. So, it's either injunction or declaration, but not damages. So aside members' direct action, another way a minority can be protected is through a derivative action. So the first is members' direct action, and I'm giving you instances where you can bring a members' direct action, about 5 of them. Then the next is derivative action. So for this, leave must be sought. Leave means permission from the court. Permission must be sought from the court. So for this, application may be made to courts for leave to bring an action in the name or on behalf of the company, or to intervene in an action to which the company is a party for the purpose of prosecuting, defending, or discontinuing the action on behalf of the company. So, here you can see that you're bringing an action in the name of the company or on behalf of the company. So, as a minority, ordinarily, if a company wants to sue to remedy anything, or it has to be agreed by the directors, But you, as a minority now, you can now sue in the name of the company. But before you can do that, court has to give you permission. So that's why you have to seek leave. Something has happened to the company, the directors are not taking any action, and it's going to affect you. It's going to affect your dividend. You have told them, let's sue, let's take action, let's do this. They said, no, we don't care. You can now ask the court to give you permission to do what they have failed to do in the name of the company. Don't forget, for a derivative action, leave must be sought. Now, you can drop your questions if you have any in the comment section. I will answer them. And you can also reach out to us by email. We'll drop that below. And if you have any question, we can answer your questions. Then aside derivative action, the next is relief on grounds of unfairly prejudicial and oppressive conduct. So a member who alleges that the affairs of the company are being conducted in a manner oppressive or unfairly prejudicial to the member or members may apply to court for relief by petition. So what is happening here is that you are a minority, and because of that, they are taking actions that is oppressive to you, because they believe there's really nothing you can do, because your voice is in your vote and you have just one vote. Very, little you can do. So you can petition the court for relief. You see that in the case of Ijale Properties Limited against Omololu Ijale Properties. So if you cite this case in your exams, you're good to go. Now, you must note that the members shares the right of action with the following: a director or officer or former director or officer of the company, a creditor, the commission, that's the CAC, any other person permitted by court in its discretion. So what this means is that when we talk about minority members being able to sue, this also includes someone who is a director or an officer or a former director, right? Or a creditor. So even if you're not a shareholder, if you're a creditor means someone that has given money to the company and the company is owing him. The CAC can also sue, right? And any other person permitted by the court in its discretion. Now, aside the 3 we have mentioned, that has to do with how a minority can be protected. We mentioned the members' direct action. We mentioned the derivative action, where leave must be sought first to sue in the name of the company. We also mentioned reliefs on grounds of unfairly prejudicial and oppressive conduct. The next is investigation by the company by the commission. Now, when I say commission, I mean the Corporate Affairs Commission. So where things are going wrong, the commission may appoint inspectors to investigate the affairs of the company. Now, they won't just wake up and come up. Most times, of course, they can do that, but most times, what normally happens is that happens on the application of a member or members. A member goes to the CAC and says, "See what's going on in my company. Please come and investigate." So the CAC sends inspectors. Two, on the application of the company itself can say, "You know what, we are looking at everything, but we seem not to be getting it right. CAC, come and inspect on our behalf." Three, on the orders of the court can order the CAC to go and inspect the company to see what's really going on. Four, the CAC can just wake up. We've heard so much about what's going on. You know what? Let's go and inspect it. Let's see what's happening. This company has been in the news for a long time. Let's really go there and see what's happening. So, the investigation of the company by the commission, it can be on the application of a member. It can be on the application of the company. It can be on the orders of the court. It can be so motu. So motu means by the commission itself. Then again, the last one is winding up on the just and equitable ground. So a minority can ask for a winding up. Even a creditor can ask the court to wind up a company on just and equitable ground. So generally, we have learned protection of minorities today, and we have stated that there are different ways, different actions a minority can bring to court to ventilate his grievances or to protect his interest. One, we said the members' direct action, which is for injunction and declaration. And we told you to note that for members' direct action, you are not seeking damages, you're only seeking injunctions and declarative reliefs. Injunctive reliefs and declarative reliefs. You definitely see that in your exams. Then aside the members' direct action, you have the derivative action. Under the derivative action, you are asking the court to allow you sue using the name of the company. And for that, leave of court must be sought. Leave in law means permission. You must bring an application seeking the leave, and it must be sought and granted by the court before you do that. Then relief on grounds of unfairly prejudicial and oppressive conduct against the member. So you can go to court and ask for reliefs against the oppression being meted to you as a minority. Then we also have the investigation by the commission. The commission can be petitioned, can be on the application of the member, investigate the activities of a company. It can, on the application of the company itself, investigate the activities of the company. It can, on the orders of the court, investigate the activities of the company. Of its own motion, so motu by itself, it can investigate the action of the company. Then also, there is a winding up on just and equitable ground. Now, we believe you have learned a lot from this lecture. We really want you to pay rapt attention as you listen to it. And do not forget to click on the subscribe button, because regularly we update this channel with lectures. So once you subscribe, also don't forget to turn on your notification so that once a lecture drops, immediately you see it and then you listen to it. The lectures are not very long, so it doesn't bore you, right? So you can, at your leisure time, whenever you're resting, wherever you are, as you're walking on the road, as you're eating, just plug your earphone in your ears and listen to the lecture. So in that, no time is wasted. All right, this is one of the best and the most veritable tool for you to learn the tips for you to ace the bar finals. If you have any difficult topic in corporate or any other course, drop it in the comment section and we're going to talk about it and break it down in the most simplest form so that you can listen to it and understand. And if after listening to any of our lectures, you don't understand what you have been taught, or you still have some areas that you need clarifications on, drop the questions in the comment section or send an email to us, and we will immediately respond to you. Please do not forget to subscribe and turn on your notification. Very important. Subscribe to the channel, turn on your notification, like this video, and share with your friends. Let them know that there's something like this. The idea behind this is really to help. It's bringing technology and law together to help law school students ace their bar finals. We thank you. Drop your comments, like the video. See you in the next call.